ಕೋರ್ಟ್ ಆಫೀಸರ್ VC ಆನ್ ಮಾಡ್ತೀರಾ ಮೇಡಮ್? ಕೇಳಿಸ್ತಾ ಇದೆಯಾ? ಥ್ಯಾಂಕ್ ಯು.
Yes. So things this thing happened tomorrow, Wednesday. Oh. Different purchase. Tomorrow. So, safety is not before this court. RSA. Second appeal. Yes. Estimate is allowed to go. Yes. Urgency. Preliminary hearing, is it for preliminary hearing? Then it will come in the regular list, Wednesday. Yes. Ah,
Page 2, 3 to 5. Page 3, 6 to 10.
yes. It is settled or to be settled? At request, at request on both sides. This matter on, when do you want? Date, 19 for reporting settlement. Yes. Yes, who has moved this? Allah, 16, serial number 16. There is no cross appeal yet. Which is that? Who has moved this appeal? Then cross appeal, give the cross appeal number. We will connect. Where is your counterpart? Yes, at request of the responding counsel, this matter next week. He's unwell. At request of the responding counsel, this matter next week. Memo for? Memo for? The counsel for the petitioner submit by the appellant. The counsel for the appellant submits that the appellant does not intend to prosecute the appeal as the appellants and this respondents have amicably settled the matter, settled the dispute, and files a memo for withdrawal duly signed by the appellants. The memo for withdrawal which has under view of the submission and memo file, the appeal is dismissed as withdrawn. Third list.
My lord, serial number 2, list 2, my lords.
Yes, list 2 we just called out for any adjournment.
My lords, list 2, serial number 2, my lords. I have little personal inconvenience because my son's admissions are going on right now in this week. Next week it may come.
Ravindra Patil or Shivraj Arli?
Shivraj early, my lords. I have Shivraj early.
At request of the appellant counsel, this matter next week.
My lords, can it be 26, my lords? Next week admission process is there, my lords.
At on the 26th.
Much obliged.
Mediator counsel submits that he is in receipt of the repetition papers on request the matter to be taken tomorrow. Is this matter tomorrow? Take notice. The CGP to accept notice for respondents number 1, 2, 3. Yes, your history. This matter tomorrow at the preliminary hearing stage itself. Yes. Yes, Madam Divya. Who is appearing? Kashmira. Vidya. No representation on behalf of the petitioner. This is matter next week. This, pass on. Serial number 3 pass over.
Second.
Tomorrow. CGP submits that statement of operations are ready and it will be filed with the registry. No, if there's only one person who is abnormal and others are there. No, there are others. And there are any other legal heirs other than the
Legal heirs is not involved in this case. It's a partnership for. Why partnership?
His suggestion is that in the event, now there is an abnormal, like mentally disordered person here.
Physically challenged.
Physically challenged person is here. Apart from physically challenged person, is there any other legal heir of the?
Not so we're not with the partnership for other partners are there. And he is not either under the partnership act or under the FIA, he is not disqualified.
Tomorrow. Maitri Krishna. Mediation report. What happened to the mediation report? What happened to the mediation? What is the scope of the mediation? Right. Then why is it so? This report on 11/7/2024. Parties were directed to appear before the Karnataka Mediation Center. The mediator was directed to assist the party in resolving the dispute. The date has been given to today, and hence the matter is listed. The counsel for the respondent submits that the mediation process is still going on, and hence the parties are referred to appear before the mediator today. Today it's going on before the mediator has run up.
In this case,
Is the mediation going on now? You don't want to be referred to the mediation? The matter is already referred. So let it go before the mediation. To go before the mediator. This one tomorrow. This is matter after receipt of the report. Yes. So when do you want? Next week. At request of the respondent counsel, this matter next week. You go before the mediation or really mediation. So Raghunath? Sir. Repeating one is now. Sir.
For one matters. Order number 1, Prashant.
What is this office objection? To rectify the office objection raised by the registry. Item number 1 to 4 of 1 to 3 of 2024. 1 to 4 of 2024. by a week. That has to be allowed. Cross objector number 2. Who is the very respondent in the connected appeal? They are different, right? Your appeal, your appellant has died, appellant number 9. And in your cross objection, cross objector number 2 has died. They are both different persons, right? See, one Vedavati has died now. Both have died. And in their appeal, who died? Who is appellant? Who is the appellant in the connected appeal? Are they the plaintiffs or the defendants?
Plaintiffs.
They are the plaintiffs. From Sridhara is reported to be dead. In your place, it's there. I one of. There is a delay. I-1 of 2020 is filed to condone the delay of 40 days in filing the LR application of deceased cross objector number 2. I-2 of 2020 is filed for setting aside appellant. I-3 of 2020 is filed to bring the LRs of deceased cross objector number 2 on record. Huh? Memo dated 26/3/2001, stating cross objector number 2 as LRs of deceased or cross objector number 1. See, first let the LRs come on record, and then this memo has to be withdrawn. You have to file a better memo saying that the LRs of the cross objector number 2 is the legal head of cross objector number 1. No objections have been filed to the application. Reasons indicated in the affidavit accompanying the application is accepted. Delay of 48 days is condoned, abatement is set aside. LRs of deceased cross objector number 2 are permitted to come on record. Appellant to carry out, the cross objector to carry out the amendment and file amended cross title within a week. Cross objector seeks to withdraw the memo filed on 26/3/2019. The text submission is recorded, and accordingly, a memo is dismissed as not present. It's to not present. File the memo saying that the LRs are the what is it? Steps to be taken. Of the appellant counsel, a week's time is in the substituted service in respect of unserved respondent. There is no interim order. So just look into the file, right? Status quo as on today. Already there. In there. Yes.
Number 3.
Yes. Notice issued to respondent number 8 has been returned with an endorsement refused. Notice to respondent number 8 is held sufficient. The history to show the name of respondent number 8 in the process. A request of the appellant a week's time is granted to do the necessary. Respect of unserved respondent. Sole appellant, when did he die? Abate. Anyway, it has been abated already. The respondent has filed a memo indicating the death of the sole appellant on 2/5/2021 by way of a
Appeal
memo,
not for
by way of a memo dated 22/12/24. On 9/8/2023, the appellant was granted time to file necessary application to bring the allowance of the deceased appellant on record. No application has been filed. The appellant has died on 2/5/2021. The appeal stands for
Having died on 13/7/2021.
7/2021. Then
Second, respondent will show as per postal Shara.
this is
I'll take steps. And point number 3, maybe it's sufficient. Respondent will 5 to 10.
unclaimed, we don't know who has not claimed it, whether he or the any other person. So you may have to take steps. Then fresh notice to 6. Who is reported to be dead? A9 or A9?
A9.
A9 is reported to be dead long back. Appeal stands abated as against appellant number 9. Notice issued to this respondent number 4 has written with an endorsement deceased. Appellant counsel seeks time to take necessary steps. And in respect of unclaimed respondent number 5 and 10. And fresh steps to respondent number 6. At request, 2 weeks time is granted. Yes. So appellant counsel seeks time to take steps to this unclaimed and then respondent. In a week's time. Respect of unclaimed, same.
In Malad, the other connected matter very important. The same Gangana who is also in served, he is also in this matter. It's only unclaimed is filing only. So it may have to be held as separation.
How do you say it is
The other
unclaimed?
matter also it is served.
No, it is served. It is served not as unclaimed. It has been served in the usual course, right? Now in this, we don't know whether he has unclaimed or somebody.
And then I have to furnish a typed copy and see to before I furnish that in the meantime.
Appellant seeks time to take steps in respect of deceased respondent number 1 and 2, and in respect of unserved respondent number 3. At request, 2 weeks time is granted. Yes, and appellant to furnish the typed copy of exhibit P32 within a week. Within
My lords, I appear for the appellants in this matter, my lords. With regard to the first matter, my lords, I will file the amended cost title ready. They will file the amended cost title and I'll amend the cost title, my lords. Second one, there are.
during the course of the day.
I will do it, madam. I'll do it, my lord.
Yes.
Second one, LR application, IS pending. If that also may be allowed, I'll amend.
Arrest is 76 minutes.
76.
Appellant counsel submits that the amended cost title and amendment of cost title and filing of the amended cost title would be done during the course of the day to verify and proceed. Next, the order in RSC 75 of 2017. I-1 of 2024 is filed to condone the delay of 133 days in bringing the allowance of respondent number 1. I-2 of 2024 is for setting aside abatement. I-3 of 2024 is for bringing the allowance of deceased respondent number 1 as respondent number 1 A to C. The proposed allowance of respondent number 1 has been duly served and represented by counsel. They have not filed any objections to the application. Third, reasons indicated in the affidavit accompanying the application is accepted. Delay of 133 days is condoned. Abatement is set aside. Alas of deceased respondent number one are permitted to come on record as respondent number one due to see appellant to carry out amendment forthwith and file amended cross title regularly. Yes.
Oblige, my lords.
By L. Srinivas.
Appellant comes. There is no representation on behalf of the appellant. I am granted to do the mediation. What is this office objections and what is this notice to the acceptance of wakalat in respect of respondent number one, bearing the sign of Gayatri, who is not a party in the appeal. And what is this application? I-1 of 2024 is for appellant number two.
This is regulation.
Appellant number. This three application are for only two applications and setting aside. Yes. Notice is ordered to the respondent.
Yes.
Other appellants are represented. You are representing all the other. Yes, I-1 of.
And also, filing the original RSA version.
That would be only condoned after the service of notice to the respondents.
Just want to bring it over there.
I-1 of 24 has filed to condone the delay 536 days in setting, 536. No, that is regarding appellant number two, right?
It came back unserved, your lordship. In fact, there, she is a daughter.
Somebody has filed wakalat for respondent number one.
Respondent by two is a daughter of respondent number one.
So take notice in respect of respondent number two. At request of the appellant, a week's time is granted to do the needful in respect of unserved respondent number two. Is paper book necessary? What is the suit for? And what is the paper book in this? You are the dependent. What is the recovery amount? 2,50,000. What is the admitted amount by you? Have you admitted the amount to some extent or you have denied the entire transaction itself? At the request of the appellant, 2 weeks time is granted to file paperwork. Who has filed the memo for retirement? You have filed the
Same Balaji.
filed by the appellant by the council Balaji AM is accepted since Vishwanath Sabrat has filed power for the appellant. Registry to delete the name of Balaji AM from the council list. Yes. 1,486 days. You have to justify what is that? Not to the extent of 10 years. Not at all. Just to 4 years. How many years? Correct. How many years delay? 2,000, right? What is the delay? 1,000. What is the suit for? What is the suit for? Partition. You're the plaintiff. Second defendant. Plaintiff suit was decreed.
Properties were declared as self-controlled property, the defendant number two is acquired. Subsequently, now it has been reduced to 2 years. One time also reduced to
What is the relation? Where is the genealogy? Where is the genealogy? There are three children. There are 3 children. Ramalinga Gowda,
Right. 91 and 2 and Ramalinga got a daughter, son, but number 193 ಅವರು. normally is over and dating is going to be people and DP are the parents.
Who is Malaygoda?
It is the daughter of the different number 193.
Ramlinga Gowda is dead. What is the contention taken by dependent 1 and 2? Correct. What is the contention taken by the dependent?
Earlier, the super subsequently reduces the third operator, the holding the two properties are also available.
So B was rejected by the trial court. B was rejected. Now before the first appellate court, what happened?
Four items were held to be the self-accord property of the different number.
That is B schedule. B schedule, schedule.
Each schedule number. Each schedule. All the different properties are held to be self-accord property of the different number 2 as well. Yes, schedule 1 and 3 are held to be available for partition and 2 and 4 were not self-accord property of the different number 2 as well.
1 and 3, 1 and 2 items were held to be the joint family property, and 3 and 4 of A schedule and B schedule were held to be the.
Self-accord property.
Where is that finding of the trial court to that extent?
That is modified and ready.
Where is the finding of the trial court? Issue number, which is that issue?
Whether the pages in the properties of the property and property friends as stated. In the affirmative judgment, that is 5 here. Number 3 is read in the affirmative, whether the number 3 is property.
Where is the issue of the trial court? Issue emergent notice on I number 1 of 2018, as well as the main appeal. No. Let me. Yes. Yes. You have not even rectified the office objections. Correct. Why they will not give the price? See, there's a specific order of this court saying that pending consideration of the IA for recalling, registry is directed to permit the appellant to rectify the office objection. The special case only you have been not being given file. No, so you have not complied. You have not complied. This order is in the month of June 2024. June. We are already in September. So how can you? You file an affidavit that they are not giving you to comply. You give an affidavit that they are not giving you to comply. How can you make a submission that they are not giving? When in all other matters they give the file and only in your matter is a special case that they don't give you. Appellant to comply the office objections pending consideration of IA for recalling during the course of the day, telling which IA for recalling stands dismissed. Short reference to the date. पूरी वापस कर से immediately assignment. There is no appearance on behalf of the appellant. Memo is filed stating the death of respondent number 1. Appellant is granted 2 weeks time to file necessary application in respect of deceased respondent number 1. The sheet is issued to respondent number 1 to file and session for endorsement. Notice to the said respondent to file sufficient. Registry to pay the name of respondent number 1 to file in the cost list as held sufficient.
My lord, the registry may also be directed to remove my name, my lord Mohan BK, because I have retired from the case, my lords.
Since Nagaraj has filed the power for the appellant, the name of Mohan BK to be deleted from the cost list.
Grateful, my lords.
Yes.
Yes, Mr. Rupoji Rao.
My lords, I appear for the appellant, my lords. I pray for a week's time to comply, my lords.
At request of the appellant, a week's time is granted to do the needful.
Oh, bless.
What is non-compliance? When the counsel for the respondent acknowledges the receipt of I-1 of 2021, hence the compliance of office of witness on I number 1 of 2021 would not arise. Yes, what is this? You have received it. Respondent person seeks time to file objection. At request 2 weeks time.
27.
Yes. Next.
17.
Also. Mr. Vinay Reddy. Who appears for the other side? Huh? Yes, sir. In further. What is the suit for? What did the trial court do? Was the plaintiff or the defendant? Where the plaintiff? Trial court decreed your suit. First appellate court? Modified the judgment and decree. Suit item number 7 is allowed. Item number 7 is sold by dependent number. Dependent number. Is allotted to the share of dependent number 1 and 2 to an extent of 20 guntas each, which is already sold in favor of dependent number 6. The dependent 1 and 2 are entitled for 19 guntas only in respect of suit item number 1 to 6. The plaintiff and defendant 3 to 5 each are entitled to 1/6 share, which works out to 39 guntas. What is wrong with this order? They have given lesser share to the defendant. Pass over, to read and come. What is this recalling order? You have complied the office of justice?
What they are seeking is for declaration and injunction. Declaration that is created which is excluded in the year 1951. The absolute say deeds are not binding on them. They are very,
So we'll recall the order and then we'll dismiss it on notice. This is I6 of 2017. So how many IAs? Why so many IAs?
they are not provided.
6 of 2017 is filed for recalling the order dated 22/9/2017. The reasons indicated in the affidavit accompanying the application is accepted. The order dated 22/9/2017 is recalled and appeal is restored to file. Assailing the concurrent findings of facts recorded by the courts below, the plaintiff is in regular second appeal. Third, the learned counsel appearing for the appellant. Fifth, seeking for declaration and injunction in respect of
Also, the stage will be 29 hours.
29. Page 29 is the decree.
Page 9 of the OS order. Para 13.
There is no para 13 here. Yes. Only one food property.
Only one property. 2 acres of land, agriculture land.
Seeking relief of declaration of title and for consequential relief of permanent injunction. Food property is land bearing survey number 36/28 measuring 2 acres. Herein referred to as food property. The case of the plaintiff is that the plaintiff's mother, Muniamma alias Muni Gangamma, purchased the suit property to a registered sale deed in the year 1951, and she is in possession and enjoyment of the suit property since the date of purchase. The plaintiff's mother, it is stated in the plaint that the plaintiff's mother did not sell, the plaintiff's mother has not sold the suit property during her lifetime to any person, and the sales transactions which has been the sales transaction in favor of the defendants has been created by the defendants, and they have managed to get their names entered in the revenue records. It is stated in the plaint that the plaintiffs are the owners and in possession of the suit property. On notice, the first defendant appeared but did not choose to file his written statement, and the other defendants were placed ex parte. the trial court on basis of the pleadings, oral and documentary evidence. Documentary evidence arrived at a conclusion that the mother of the plaintiff has sold the property in the year 1951, and the possession of the property has been delivered to the purchaser, and the plaintiffs have failed to prove their title and possession over the suit property, and accordingly, by the judgment and decree, dismiss the suit of the plaintiff. Appeal preferred before the first appellate court. The first appellate court, while reappreciating and reconsidering the entire oral and documentary evidence, concurred with the judgment and decree of the trial court and dismiss the suit of the concurred with the judgment and decree. The plaintiff suit is in the year 2005, seeking for a declaration on basis of a sale deed which was executed by her mother in favor of the defendant. Which defendant?
14.
Defendant number 14 by registered sale deed dated
29th of May 1920.
as per exhibit P3 dated
25th May 1951.
25th May 1951.
Yes.
And what is exhibit P2 to P5?
So C1 is the sale deed which was there in favor of the plaintiff, 10th of May 1951.
So she purchased in the year 1951, 10th May, and after that her mother has sold. Exhibit P1 is the registered sale deed executed in favor of the plaintiff's mother on 10th May 1951. Exhibit P2 is the registered sale deed dated 25th May 1951. 1951 in favor of defendant number 14. The suit is of the year 2005. The burden was on the plaintiff that the mother of the plaintiff had not executed the registered sale deed as per exhibit P2 in favor of defendant number 14. Other than mere contending that there is no execution by the mother, there is no contention raised by the plaintiff as to about any other averment regarding the sale not being in favor of defendant number 14. The law is well settled that in light of the amendment of Act Hindu Succession Act 2005, and in light of the judgment of the Appellate Court in the case of Vinita Sharma, any sale prior to the cutoff date of 2004 stands protected. In light of the decision, the sale deed which was executed in the year on 25th May 1951 stands protected. And the trial court and the first appellate court has rightly dismissed the suit of the plaintiff. The manner in which the courts below have considered the entire oral and documentary evidence. This court is of the considered view that the same does not warrant any interference under section 100 CPC. No substantial question of law arises for consideration, and this court passed the following order. The regular second appeal is hereby dismissed. The judgment and decree of these courts below stands confirmed. A paragraph. All of your own. This is one for what? Partly the injunction. You are the plaintiff. You are the plaintiff. Admission ga final year hai. Cost kodi nim association ge clerk association cost kodi. IA2 of 2023 is filed for recalling the order dated 2023. Reasons indicated. ಯಾರು affidavit ಹಾಕಿದ್ದು? Who has filed the affidavit? ನಿಮ್ ತಪ್ಪಿಗೆ appellants ಯಾಕೆ affidavit? You should file your affidavit. You should file your affidavit. ನಿಮ್ party present ಇಲ್ಲ ಅಂತ dismiss ಮಾಡಿದ್ಯಾ? No, because your absence we have dismissed. It's your fault, not the fault of the appellant. Accepted. The order dated 24/5/2023 dismissing the appeal for non-prosecution is recalled. Appeal is restored to file. This is the matter for admission. Subject to the cost of paying 2,000 to the clerks. Benevolent within a week. That's our recording. Yes. ಇದು ಸೇಮ್ ಕಂಪ್ಲೈ ಮಾಡಿದ್ರಾ? ಮಾಡಿಲ್ಲ ಅಂತ ನೋಡ್ಬೇಕಲ್ವಾ ಫೈಲು. I1 pending consideration of I1 of 2019. Registry is directed to permit the appellant to rectify the office objections. All on Monday. ಬೇರೆ ದಿವಸ ಇದೇನು ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ನಾನ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ 17ಗೂ ಪ್ರೆಸೆಂಟ್ ಇಲ್ಲ, 20ಗೂ ಪ್ರೆಸೆಂಟ್ ಇಲ್ಲ, 23ಗೂ ಪ್ರೆಸೆಂಟ್ ಇಲ್ಲ. ಸೊ 3 appeals different time. ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಬಂದ್ರೆ ನೀವು ರೀಕಾಲ್ ಮಾಡ್ಸಲ್ಲ. ನಾವು ಸೇಮ್ ಆರ್ಡರ್ recalled. Post for admission subject to payment of cost of ₹2,000 within a week. ಇದು 19, 17 present, 19 present ಇಲ್ಲ, 23 present ಇಲ್ಲ. Yes, non-compliance. Pending consideration of I1 of 2023. Appellant counsel is permitted to rectify the office objections. Registry is directed to permit the appellant counsel to rectify the office objections. Yes. What is this recall? You have complied the office objections now? Pending consideration of I2 of 2017, appellant counsel is permitted to rectify the office objections. Yes. Registry is directed. Patabi Raman. For what it has been dismissed? For what reason was it dismissed? Have you complied the office objection? Pending consideration of I number 2 and 21 of 2020, I1 and 2 of 2024. Registry is directed to permit the appellant to rectify the office objections. Yes. Comply mad banni. What is this I1 of 23? You are, have you filed objections? Have you filed objections? Objections hakidira? Have you? You have filed. You are the defendant. And now suit is dismissed on the ground of non-joinder of necessary parties? No. What? Then now the pleading applicant wants to come on record. They are the family members, right? So we'll consider this application along with the main. Is it not? See, this is an application where they are the they belong to the family of
Mohammed Daljeet, Mohammed Wajid, Feroz, there will be legal action of Mohammed Ghaus and Pratham. All the members are made as the parties for the.
Majib.
Except Abdul Wajid.
Abdul bit today. First only say Majid, Wajid, Surjan, Nurjan, Dilshad, Tajunisa, Ihana, Shalila, Khalila, Abid. Yaar, who is not made as a party?
Abdul Wajid family members. Again, Abdul Wajid.
Wajid.
How they have an application to be considered as a party?
You have no objections to allow. Who has any objections? Nobody has a. I-1 of 2023 is filed by the pleading applicant to come on record as respondent number 13 to 20. The proposed respondent. The proposed respondent contend that they are the legal heads of Abdul Wajid, who is the son of Mohammed Ghaus. And they are the members of the joint family. Really, joint family el barata. Where is the concept of joint family? Members of the family. And the present suit is instituted by the respondent number 10 and 11, seeking partition and separate possession. And the respondent 10 and 11 bar plaintiffs are the children of. Who are the children? Plaintiffs are the children of whom? Noor Ahmad.
Bashir Ahmad and Noor Ahmad.
In the other, which number? Which number they are? Nurjan. Plaintiffs 1 and 2 are the children of Mohammed Ghaus and Khatun B. And aunts of the present pleading applicants. The respondent, the plaintiff, and the appellants. The appellants, who are the appellants now?
Apart from plaintiff, remaining defendant are the appellants area. Number 1.
The appellant and the respondents have no objections to implead the proposed impleading applicant as respondent number 13 to 20. Accordingly, no objection. Amelia, the proposed respondent number 13 to 20, being the legal heirs of Abdul Wajid, and they being a necessary and proper parties to the proceedings. I-1 of 2023 for impleading is allowed. Yes, respondent number 13 to 20 are permitted to come on record, and the appellant to carry out amendment and file amended cost title. In was it state? If the order granted earlier is extended to the next. Yes. Yes. Who has filed this early hearing application? What is the suit for? And you are the? Who is the appellant? Plaintiff is the appellant. What happened to the suit?
Suit was part a decree. And there were two appeals filed before the appellate court. Both the appeals have been allowed. Conflicting judgments have been rendered, resulting in uncertainty of the share and all that. Therefore, the appeals are required to be heard. I have no objection for the date fixed.
Plaintiffs and defendants 2 to 5 are entitled for equal share in the suit scheduled property. What happened before the trial court?
Trial court granted decree only in respect of two items of the property. The two different yes.
It differentiates by the first trial court. Where is the family tree? The plaintiffs are the children of one Veerbhadrappa.
Yes.
And defendants also are the children of Veerbhadrappa. And according to the plaintiff, the suit property are the joint family property of Veerbhadrappa and the plaintiff. Trial court said only in respect of some properties they are entitled for 1/6 share. Now they would be entitled for 1/6 share only. What is wrong with the order of the first appellate?
No, data. There are defendants who are married. They were married even prior to the.
That is not all contention settled. ಇದರಲ್ಲಿ ಏನಿದೆ ಹೇಳಿ? If you tell the date of your choice, any date andre, even today is an any date. The court sits from morning till evening here, so it's always convenient for the court.
Yeah, today.
So tell the date of your choice. Yes.
2 weeks.
Huh?
2 weeks.
Why
2
2
weeks.
weeks? Why 2 weeks? Because it's just a partition suit. Why should we keep this matter pending? Alva. And for you, it is just to look into the file. With so much of experience, you just need to look into the file. So they give a date, we'll list it on 19. At the first of the appellant counsel. At the very stage, please. Yes. 19. Sole respondent second time. At request of the appellant counsel, a week's time is granted to do the needful in respect of answer, in respect of the sole respondent. 1 week. Same. Where is the appellant? Have we filed objections to this application? You want to file or don't want to file? Respondent counsel seeks time to file objections to I-1 of 2007. At request, 2 weeks time is given. Yes.
Number 2, madam. This is the Logan.
Cost kotra. Settlement, you mentioned something about respondent.
According because he has personally conducted the case in the party before the OS.
Hmm.
Let it not be a favor. As I said, you plead and request to the court how much time you want to take.
Extra precautions by the party. ಈಗ ಏನು settlement? Is there any possibility of settlement? You know,
They are not the parties before the trial court.
who are not parties?
The female daughter. They have been arraigned in the appellate court. ಅದರಲ್ಲಿ ಅವರಿಗೆ ಶೇರ್ ನಲ್ಲಿ ಒಂದು ಸ್ವಲ್ಪ ಮಾರ್ಕೆಟ್ that's why he wanted a month's trial. I thought
Month's time and all we will not. You can tell your party in person. But month's time we will definitely not grant. Now he is the who are you? The appellant,
and the second
dependent number 2. Where is the family tree? Did you get it? Yes. Ramegowda, Timmegowda. So Ramegowda's son is Balyamma. Yamma 1. Then Nagamma. Then Sheshamma. Who is the plaintiff here? Timmegowda. Puttegowda and Kirti Kumar. Puttegowda is fourth son. That is the plaintiff. And Kirti Gowda, plaintiff number 2. And then Nagappa Gowda. Nagappa Gowda,
the second.
Nagappa Gowda. Who is dependent number 1. And you are dependent number 2. Chinne Gowda. Dependent number 2. What happened to the suit?
For item number 12, it is eschewed.
Where is the suit property schedule? Page number 99. So these are the suit properties. 13 suit-
Altogether, 13 scheduled property. Suit number 12 is eschewed on the ground that it is a self-acquired property of the one of this. That is created 13.
Only 12. Only 12 was the dispute.
11, 12, ಎಲ್ಲವೂ self-acquired ಅಂತ ಹೇಳಿ.
No, dependent number 2.
That has been eschewed.
Only 12 has been held to be the self-acquired.
The 2 appeals have been filed, one by the first defendant on the ground that ticket number 11 to 13 are the self-acquired property. 11, 12 and 13.
Correct.
The trial court included only eschewed 12 in spite of the defense that 11 to 13 are the self-acquired.
So the first appellate court dismissed both the appeals, confirmed only to 12.
Now they are mediating with regard to the sharing the allotment.
11, 12 and 13. 11 and 13. 10 also.
My defense is there was already a partition.
That has been disproved by both these courts.
We have produced the document. The trial court is relying upon a court and trial. But we have taken different steps in the
Registered partition. Huh? No.
oral partition, parties have been separate, documents have been. That are someone who gets a
10 to 13, he said it's his self-acquired. But both the courts have arrived at a conclusion that
Then in respect of 12 is a self-acquired property. However, it has been granted, 11 and 13 are included ಮಾಡ್ತಾರೆ. 12 ಅನ್ನು ಬಿಟ್ಬಿಡ್ತಾರೆ. Their stand is that 11 to 13 are the self-acquired property. The court says 11 to 13 are the 11 and 13 are the family joint family property. However, choose item number 12.
where do they say, where is the finding of the first appellate court to that effect? So when,
He gone through. He will load again because he wanted to say.
see, their appeal also, their appeal is against non-granting of share in item number 12. Your appeal was in so far as granting share.
And saying there is a.
Yes, you said that there is a previous partition and also your
And
contention.
also contained in the item number 12 is to be a joint venture property.
And that should not be, it should be the self-acquired property of defendant number 2. Now, your contention has been disbelieved by the first appellate court. First appellate court dismisses both the appeals. So confirms the order of the trial court insofar as item number 12 is concerned. Then,
ಅಲ್ಲಿ ಒಂದರಿಂದ 13 ಬಾಕಿ defendant ಸೇರ್ತು.
your prior partition is also disbelieved.
They will not be disbelieved and the documents.
Correct, disbelieved. Now it is disbelieved, yes.
As of third is.
Yes, disbelieved. Now, what is the settlement now which you are proposing?
The female members were not the parties before the trial. They have been joined and included in the first appellate court. It is therefore not the share regarding the female members after the amendment. They want to with regard to the money and other things where talks are going on. Therefore, he wanted a essential time of 1 month. I said, I can only
We will
request
give you
up to
at the most, yes, we will give you some time. If you don't settle, we will hear this matter on merits and we don't know what will prevail upon this court to either, yes, you know, but the party in person also should know. Tell him clearly that this court will not give him any adjournment after, when is the date which you want? We are in 12th today and next week is 19th and another is 26th. Tell him that we are not inclined to even admit the appeal. Tell him that we
ಮಕ್ಕಳಿಗೂ ಎಲ್ಲರಿಗೂ ಬಾಲ್ ಕೊಟ್ಟಿದ್ದು ನಾನು ಕೊಡಿಸ್ತೀನಿ.
ಕೊಡ್ಲಿ ಅದಕ್ಕೆ ಎಷ್ಟು ಲೇಟ್ ಮಾಡಬೇಕು? When is the suit?
It's a suit of the year
2003.
3.
Ah,
It is of the year 2016.
how many years? 21 years.
Even then the situation is same. It's
Nothing
no
changed.
conclusion.
Then
ಅವರೆಲ್ಲ ಏನ್ ಮಾಡಿದ್ದಾರೆ ಎಲ್ಲರೂ ಒಬ್ಬೊಬ್ರು ಒಂದೊಂದು ಜಾಗದಲ್ಲಿ ಹೋಗಿ ಅಲ್ಲೇ ಇದ್ದಾರೆ ವಾಸಿಸ್ತಾರೆ.
let him do something because the appeal is of the year 2016. 2016. He did not do anything for so many days.
ಅಲ್ಲಿ ಸೆಟಲ್ ಮಾಡ್ತೀನಿ ದಿಸ್ ಇಸ್ ವಾಟ್ ವಿ ಕಾಲ್ ರೈಟ್. ಆಮೇಲೆ ಸೆಟಲ್ಮೆಂಟ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ನಾನು ಅಪ್ಲಿಕೇಶನ್ ರಿಸ್ಟೋರ್ ಆಯ್ತು ಆಮೇಲೆ ಸೆಟಲ್ಮೆಂಟ್ ಇದೆ ಅಂತ ಹೇಳಿ ಮತ್ತೆ
He is not sure as to what is he is going to do. Yes. Appellant counsel seeks time to report settlement as a last chance. This matter on 26 to report settlement or to argue the matter on merit. 26 or argue the matter on merit. Yes.
So item number 3, Shankar Reddy.
Yes, Mr. Shankar Reddy. Should we do now? What do you want? If he's engaged in some other court, he will come, right? Will he be always engaged there? No. You don't want to argue today. Why? Ask your senior to come pass over. Was this matter heard? Was this matter heard on the last occasion? Is it not? What's wrong with you? At request of the appellant counsel, this matter on 19th. Yes. As a last chance.
You go. Kirama.
Rambert avara bani.
Shankar Gowda.
Vote for
last time I was asking for
settlement.
This also going on. The thing is this. We have I have only association, welfare association. My members purchase the sites. And the plaintiff to claim the right of the covered is property. The cloud or the property. Simple suit filed for injunction by the plaintiff. That has been dismissed. In appeal reversed. They will find. Now I asked the other side, they are ready to pay some amount, they are also ready to accept. The thing is, what is the amount? I thought up to 1,700 plus per.
What is the price? What is the market value of
After
it?
that, the woman I think it's here in Tamil, it's 4,000.
4,000.
4,000. Near electronics, Apple electronics. Yeah.
Correct. In the event you want to purchase the property
Please.
or you want to sell the property, what would be the amount you would be paying? It should be vice versa, alva. Hangiದ್ರೆ
That also told.
if you are ready to take 1,000 at the rate of 1,700, then you should also offer only 1,000.
They have been formed, we are in perspective. Under 70% of out of this is only the this.
Now you're a trust. You're a trust. Alva.
That's why I selected for that one. We are ready. Some bargaining is gone. Going on. That is the thing. Simple superimposition that type is association is not maintainable. There are cloud over the type of that is the binding of the type. But in the appellate court, what is the binding regarding title and sovereignty, just like a declaration. Sovereignty. SI parties are not there.
What is this application filed? Who has filed this application?
In Myanmar, but writing solo property that you will file for various persons and creating the party.
So now
Once I give my favor,
you have to show an inclination for settlement because there are third party rights.
the morning also to Dora never told. People they want to meet, the parties are not to meet person will be minister, I don't know why.
We'll pass over, ask him to give a proposal for settlement, otherwise it will never happen.
Also, if you have 2,000 they came, that part is like Dora, Dora. They may have to see. That is the only full stop this
See, the
litigation.
settlement is benefited to you rather than.
There is a site on your purchase as a monopoly purchase. Thereafter start because as a partner, there is a
He
partner.
was the owner of the property, the respondent was owner of the property.
According to this, not like that. The partnership almost there. It is we have 3 persons. Each fundamental partner. He was in imprisonment for some other.
Oh, this Muniappa.
No, that Sitaram. And Muniappa sold the property. Another partner.
Sitaramaya. So,
Sitaramaya, see, they are purchasing several properties. This thing, that one, like that. Sitaramaya is also a partner. Muniappa is also a partner. They are the purchasers. Now put into trust.
so the Sitaramaya has sold this property to
To
Muniappa.
some other persons.
Then
Muniappa sold the property to me.
So you are how much?
Not my members, not my numbers.
Third purchaser, you are the third purchaser.
And that much. By sideways, we have purchased. They have developed the layout.
What is the extent of the entire?
1 acre, 2, 6. Sideways, they have formed the layout. Portion has been converted. Everything has been done.
He says he has purchased this property in the year 1993.
Then we have purchased the property.
The plaintiffs say they have purchased the property.
No, plaintiff sold the property in their third person after valuation.
The government at page number 76, Nori, the plaintiff has purchased this.
By any, by 2 after money. Actually, supervision is not maintained. Owners are not, the subsequent purchaser, when he sold the property, he's not entitled for injunction. He's not in possession.
No, he doesn't say that he has sold the property.
But what is the document? Subsequent, I came to know it. On the same day, what is because it's all
The
about now.
plaintiff's contention is
He's the one.
he is the owner under a register sale deed, which was executed in his favor in the year 1993, and that defendants had no right over the suit property. Whereas your contention is
We have no right. It's not a suit, it's not property name. That is the finding of the trial court. Because this, it's plaintiffs. No way connected to the, they are not the owners, they are not paying any title over the property. Sorry, the defendants. I am the welfare association helping my members and maintaining the layout.
when did you purchase the property?
95 onwards. Not I, my members.
Correct, your trust, when did it purchase?
95 onwards, there are so many documents I have produced. Exhibit 21 to onwards. That is the sale deeds. Agree to D22, D25, receive thereof the sale deeds, affidavits. Agree G28 to B85 are the sale deeds. There are my members. They executed some, 2005 only, they executed sale deed, nearly 12 or 17 sale deeds. And created some other right over the property. That is a dispute. Now we have approached that subsequent purchasers and they are ready coming forward to sell it under Sitaramaya.
These plaintiff and the defendants were partners of one firm.
Plaintiff and Sitaramaya was a partner.
The defendant number one,
Please.
they were partners. So then the partnership deed was on 1/4/1992.
What development of layout and structure?
But the partition, the first defendant has got a say deed. Give deed on behalf of the firm and the same is by.
And some proud of the fact that also they did. And the partnership deal, whether he got the right to partner, that is not discussed with that. It was simple, simple English formatting. Now, one step further, I have filed a suit for declaration before trial court is finished.
Declaration that you are
Because
given
of
on
title.
basis of a
Yeah,
second.
because there is, comprehensive suit is required, by injunction, it cannot be decided. Only can disturb the position or something, by injunction. No end for that, that's why I filed a declaration, sir. Members, all the members together joined regarding that 1 acre 6 guntas, filed declaration is filed.
This society has no connection with this partnership which has been of between the purchase.
We have a welfare association, help our members.
Welfare, nice welfare. What do you want to do now?
It's been admitted, my lord. In the meanwhile, they will,
You have to take the certificate.
this one.
TCR to be secured. TCR Barley. Both.
Fine. Now let's take.
Yes, what is this? Puja Ballaya. What is this Puja Ballaya? You are the plaintiff or the defendant? Whose appeal is this? Defendant's appeal. Whose appeal is this? Second appeal yardo. Who is the plaintiff or defendant? For the plaintiff. You are for the defendant. ಅಂತೆ ಕೇಳೋದು ನೀವು ಪ್ಲೇಂಟಿಫ್ ಡಿಪೆಂಡೆಂಟ್ ನೀವು ಪ್ಲೇಂಟಿಫ್ ಅಂತೀರಾ ಡಿಪೆಂಡೆಂಟ್ ಅಂತೀರಾ ಹೇಗೆ ಆಗ್ತದೆ ಯು ಆರ್ ದಿ ಡಿಪೆಂಡೆಂಟ್ ವಾಟ್ ಇಸ್ ದ ಸೂಟ್ ಫಾರ್ correct what was the suit what is the correct. What is the suit property
Property is 2.5 feet into 27 feet enclosed by the respondent.
2.5 into 7 feet. What happened before the trial court?
Basing on the appellate agreement, to be dispute.
Agreement between you and the plaintiff. Plaintiff and defendant. Your neighbors. The neighbors. Trial court, what did the trial court do? Hello, what did the trial court do?
What they were thinking.
Dismissed it. Then, first appellate court,
Not the counterclaim of defendant. Now that and the not only agreement between the plaintiff and
who
defendant.
filed the counterclaim? Defendant. Then why are you before this court? Allowed your counterclaim, right? Allowed.
Next one, dismiss this to the.
Mr. Bhujavalaya, you're before this court against the dismissal of your counterclaim or against the granting of injunction. Against, and what about the injunction which has been granted in favor of the plaintiff? You have not challenged that order. Where? Where have you challenged? Suit of the plaintiff for permanent injunction is hereby dismissed with cause. What was your counterclaim? What was your counterclaim?
The agreement between the plaintiff and the defendant, there. Not entirely the it's a draft document created by the plaintiff.
Sorry, written statement. Where is your counterclaim, Mr. Counsel? Where is your counterclaim? You have admitted the agreement. You admitted the agreement, but you said that the rules and condition as per the agreement was violated, and hence the agreement was not acted upon. Hello, but you have not disputed that agreement.
Don't yes, they are not admitted the agreement.
The written statement speaks.
The
You-
written statement also denied the.
Kindly read your written statement. Read your written statement. Okay. We come to page number 9 of your written statement. Hmm. Come to para 20 of the written statement of yours. How do you say it is now? You have not admitted. Yes, Mr. In a written statement, Lily, you have admitted. And how does the trial court hold that you have to be confronted with the document when you have admitted the execution of the agreement itself? Alva? ಅಷ್ಟೇ ಅಷ್ಟೇ ಅಲ್ವಾ ಭುಜ ಬಲ್ಲಯ್ಯ ಭುಜ ಬಲ್ಲಯ್ಯ ಅಷ್ಟೇ ತಾನೆ ಪಾರ 20 ಓದಿ What is this? You have admitted. Next. Sadri. So you said there is an agreement, but certain terms and now see when the parties to the suit.
That is not agreed by the.
ನಿಮ್ಮ written statement ನೀವೇ ಓದಿದ್ರಲ್ಲ ಈಗ it was not your written statement ಹೌದಾ
Agreement is not unregistered agreement.
unregistered agreement. It is not possession, it is not anything where possession is to be delivered. In this case, it is an agreement which is undisputed between the plaintiff and the Amma. Alla, you read Alva, Mr. Bhuja Ballaya, you have read the written statement now. Alla, did you not read the written statement? Mr. That's all. Okay, no? Yes.
That is not admitted in the law.
Yes. No. Nothing than the written statement now. Your written statement is very clear. Assailing the legality and correctness of the judgment and decree in RA 57 of 2016, dated 11th October 2017, on the file of the Senior Civil Judge Channarai Patna, wherein referred to as First Appellate Court, reversing the judgment and decree of the trial court. The judgment and decree invoice number 307 of 2011, dated 1st August 2016, on the file of the Civil Judge and JMFC Channarai Patna, bracket number trial court was not, whereby the First Appellate Court decreed the suit of the plaintiff for permanent injunction. Parties herein are referred to as per the rank before the trial court for the sake of convenience. Suit seeking for permanent injunction, restraining the defendant from interfering with the peaceful possession and enjoyment of the conservancy and ONI, and to put up water pipe in the ONI situated towards the eastern side of the suit scheduled property, let's say 27 and a half feet towards north-south and 2.5 feet east-west. The plaintiff avers that the plaintiff is the owner of the suit property and has purchased the same from his aunt in the year 1991 to a registered sale deed. That the defendant is the adjacent owner of the suit property and has purchased the suit property from his aunt, Virama. It is the case of the plaintiff that the property purchased by the plaintiff and defendant was an old building, and they demolished the building and constructed while constructing the new building, the plaintiff and defendant towards eastern side of the back of the scheduled property, there is an Oni and conservancy. Towards western side, there is a Kalyani Road, main road. And at the time of construction, the plaintiff and defendant entered into an agreement entitling the plaintiff to use the said Oni and put up pipe the said Oni. It is a case of the plaintiff that the defendant is trying to put up. It's the case of the plaintiff that when the plaintiff tried to put up lavatory pipe and the water pipe, the Oni, the defendant obstructed and hence the present suit. On notice, the defendant appeared and filed his written statement. The defendant admitted about the agreement dated 21/7/2001 agreed between the plaintiff and defendant. However, contended that the plaintiff has violated the rules and conditions mentioned in the agreement dated 21/7/2001 and the agreement was not acted upon. The defendant contended that the plaintiff has no right, title over the said Oni, and the present suit is filed to harass the defendant, sought for dismissal of the suit. The trial court on basis of the pleadings framed the following issues, page number 30. In order to substantiate their claim, the plaintiff examined himself as PW1, marked documents at exhibit P1 to P25. On the other hand, the defendant examined himself as PW1 and marked documents at exhibit B1 to P30. The trial court on basis of the pleadings, oral and documentary evidence, arrived at the conclusion that the plaintiff has failed to prove that towards the eastern side of the suit property, there is an Oni measuring 27.5 feet towards north-south and 1/4 feet towards east-west. That the plaintiff has failed to give details such as the date of execution of the agreement and what were the terms and conditions having taken place between the plaintiff and defendant during the said agreement. And that the defendant denied the execution of exhibit P2 during his cross. And the execution of the document by defendant is not proved. By the judgment and decree, the trial court dismissed the suit of the plaintiff. Agreed. The plaintiff preferred appeal before the first appellate court. The first appellate court, while reappreciating and reconsidering the judgment and decree, by reappreciating and reconsidering the entire oral and documentary evidence, reversed the judgment and decree of the trial court and declared the suit of the plaintiff, granting permanent injunction, restraining the defendant from causing obstruction to the use and enjoyment of the conservancy lane and to lay pipeline for passing of toilet water and rainwater. The agreed by the decretal of the suit of the plaintiff by the first appellate court. The defendant is before this court in the regular second appeal. Third, the learned counsel for the parties and produced the material on them. The suit of the plaintiff is for injunction in respect of an area measuring 27.5 feet and 2.1/4, which according to the plaintiff is an Oni. The case of the plaintiff rests on exhibit P2, the agreement which has been entered between the plaintiff and the defendant. The defendant in his written statement has admitted about the agreement entered between the plaintiff and defendant on 21/7/2001. The relevant portion of the written statement at para number 20 reads as under. The defendant, having admitted in his written statement about the execution of the agreement dated 21/7/2001, the trial court was not justified in arriving at a conclusion that Exhibit P2 is not confronted and that defendant number 2 has denied the execution of Exhibit P1 and that the plaintiff has failed to prove Exhibit P2. The admission by the defendant in his written statement does not require further proof. And the trial court fell in error in holding that Exhibit P2 is not proved. Neither the plaintiff or neither the averment in the written statement would indicate any averment by the defendant that the agreement does not create any right in favor of the plaintiff. What can be gathered from the written statement averment is that the terms of the agreement was violated by the plaintiff, and as such, she could not use the clause 8 of the agreement as agreement, clause 8 of Exhibit P2. The first appellate court, being the last fact finding court, has appreciated the entire oral and documentary evidence. And by framing point for consideration, it reads as under page number 10. The first appellate court at para number 16 and 17 has given the reason as for reversing the judgment and decree of the trial court. When the document placed reliance by the plaintiff is not disputed, the reasoning accorded by the trial court in dismissing the suit of the plaintiff for permanent injunction is not acceptable. The manner in which the first appellate court has reassessed and reconsidered the entire oral and documentary evidence. This court is of the considered view that the same does not warrant any interference under section 100 CPC and no substantial question of law arises for consideration in the present second appeal, and this court has the following order. The regular second appeal is dismissed. The judgment and decree of the first appellate court stands confirmed. Mother-in-law, daughter-in-law, and mother-in-law. In her son's property, she is entitled for equals.
ನಾನು ಹೇಳಿದ್ದೀನಿ ಸಜೆಸ್ಟ್ ಮಾಡಿದ್ದೀನಿ ನಾವು ಮಾಡ್ಕೊಡಿ ಪ್ರಿವಿಯಸ್ ತಿಳಿಸಿದ್ದೆ ಈಗ ಅವ್ರು ನನಗೆ ಅವ್ರ ಬ್ರದರ್ ಮುಖಾಂತರ ನಮ್ಗೆ ಬಂದಿದ್ದರಿಂದ ಅವ್ರ ಬ್ರದರ್ ಹೇಳಿದ್ರು 20th date fix. Otherwise I will not be the man.
Why did you get her here? See, look at this. She is the mother-in-law. Where is the daughter-in-law? Daughter-in-law is happy.
Brother inform ಮಾಡಿ.
Why did you get her? Look at ask. We will dispose of.
I will not be the matter.
She's aged. What is her age? Then
One son. Was government employee. He died. Appointment ಆಗಿದೆ working ಮಾಡ್ತಾ ಇದ್ದಾರೆ. Pension ಬರ್ತಾ ಇದೆ. That's why I am getting
he has lost her son. He has lost her son. You have already been employed somewhere. What she should do? She has got only daughters. She
I
has
have
got-
suggested
suggestion immediately implement ಆಗಬೇಕು. Otherwise, what is the purpose of this?
ನನಗೆ ನೇರವಾಗಿ ಅವರು ನನಗೆ ಕಾಂಟ್ಯಾಕ್ಟ್ ನಂಬರ್ ಇಲ್ಲ. ಅವ್ರ ಬ್ರದರ್ ನನಗೆ
Otherwise, we will hear this matter on merits, Alma.
ಅದಕ್ಕೆ 20th ಒಂದು ಡೇಟ್ ಫಿಕ್ಸ್. Otherwise definitely I will go argue the matter on that day.
Suit of the plaintiff is decreed. She is entitled for 1/3. She would be entitled only till her lifetime. Are you waiting for something else?
20th.
If she gets a share, there is, otherwise we will do something about it. 8A, it is applicable to the mother-in-law. Alva, Lakshmamma. She was 80 years when she was in 2014. 10 years, 90 years. When she will get the fruits of this decree? Look at her state.
ನನಗೆ ನಾನು
Is
ಸಜೆಸ್ಟ್
it not appealable to you?
ನಾನು ಸಜೆಸ್ಟ್ ಮಾಡಿದ್ದೀನಿ. ಹೇಳಿದ್ದೀನಿ ಮೇಂಟೈನ್ ಆಗಲ್ಲ ಅಂತಾನು ಅವ್ರಿಗೆ ಹೇಳಿ.
It just takes us 2 minutes to just dismiss it. Yes. Final decree ಎಲ್ಲಿ ಬಂದಿದೆ?
ಇಲ್ಲ ಇನ್ನು ಫೈನಲ್ ಡಿಗ್ರಿ ಈಗ FTP ಈಗ
Now you have initiated.
ಆಗಿದೆ ಸರ್. It was filed for the file.
We did not stay the proceedings around. That is why they are not even pressing. Tomorrow, Mr. Consul, not before, not any date after that. You want to report settlement, report tomorrow itself. Otherwise, we will not. No, don't look at the calendar itself. We are not going to give you any other day. Otherwise, we'll hear it today only. This matter tomorrow. Request of the appellant. Karpon Barbadi avarna. Mr. Omkara Murthy. Ask her not to come tomorrow. Yes, Mr. Serial number 9. I think there was a mention made by the consul. It's urgent. It's urgent. It said they said they have informed you. They moved at 10:30. Yes. Is what happened, Mr. 36/2023, that is registration. What is to be done before 36/20? So then you have to issue him. the payment of tax and fee is paid before. Yes. So according to you, NIC is a necessary party to this proceeding. Is it so? So is it, are they necessary party to this proceeding? So you let them implead a forthwith to take, who take notice for no, learned counsel appearing for the Union of India submits that NIC, National Informatics Center, NIC person, is the controlling authority of the portal, and he is a necessary part, and it is a necessary party to this red petition. The petitioner to plead the National Informatics Center forthwith, petitioner to amend the cost title. Learned counsel Vaibhav Mallimat is directed to accept notice for National Informatics Center. So include NIC as respondent number 4. So we'll dispose of this matter with this observation. Anyway, that would be just a formality now. This matter on at the preliminary hearing stage itself on 18th. Okay. Further hearing in admission or it is in final hearing? Final hearing, admitted. Okay. Just a moment. The first appellate court was justified in declaring the suit in part in respect of items number just a moment. Patel Shinge Gowda is defendant number 1 and Lakshmana is dead. His wife is Sushila, who is the plaintiff. Jay Kumari is defendant number 8. Her children are defendants 2 to 7. Suit is for the partition. The suit is dismissed on the ground that during the lifetime of father, it is not maintainable. Suit was the self-acquired property of defendant number 1. There are 2 suits, huh? 2 suits.
Only one.
So dependent in RSA 292. Just a moment. The suit for partition was dismissed by the trial court. Appellate court decreed in part except item number 10. Item number 4 and 11. So, no, what was decreed? Other items were decreed except item number 4 and 11. 4, 10, 11. In page 24. Just a moment. Just one minute. Plaintiff and first defendant. Plaintiff and first defendant, that is the father. First defendant, are each entitled for half share.
In respect of this call.
In respect of item number 123, 529, 336, and first defendant is number 10, 4, 10 to 12.
As against, my lord, 4, 10, 12. My lord, the appeal is very, as a number 987.
So they are against the rejection of that item number.
As far as my lord,
What about this Jai Kumar? She is not given any share, dependent number. She is the second wife. During the lifetime of first wife.
the first wife, Lord, is also.
So one second. So in light of this Revana Siddhapa's judgment, now what happens? The second wife children would be getting notional partition between the plaintiff and defendant number 1. In the share of defendant number 1, they would be entitled for share. That's all.
The first wife and second wife.
They would be entitled for that share. Now the question is regarding the item number 4, 10 to 12. It has been rejected. What is that? The averment?
Yes, one product one today.
Well, where is the properties with property sources? What is her share entitlement? Entitlement of this dependent share? See, other self-acquired property, they would be entitled after his death. Correct. How many maklu? Ida yola, ara. So then 6 other. So they would be entitled for 1/12 share. 1/12 share. In the share of the father. No. We are not talking about the self-acquired property, the ancestral property. Ancestral properties, they would be entitled for 1/12 share. Correct, half share.
It has been declared to be entitled to option. So is the correction. After specified manner, this half share would be divided among each.
Correct. That would be 1/12 share. In his 1/2 share, this daughter, no, it would be 1/14 share. Because the plaintiff also has to be given. So 1/14 share. So 7 sharers, plaintiff would be getting 1 share and other defendants would be getting, that is defendant number 2 to 7 would be getting 1 share of in the half share of defendant number 1.
Yes.
Ancestor. Insofar as the self-acquired property, that would be only after the death of the father of. If at all you want to settle, that is something else. Not. She only wants 2 acres. What is the total extent of land? 8 acres. So 8 acres ನಲ್ಲಿ 1/14 ಅಂದ್ರೆ ಎಷ್ಟು ಬರ್ಬೇಕು ಅವ್ರಿಗೆ? 1/14 ಅಂದ್ರೆ ಎಷ್ಟಾಗತ್ತೆ? ಎಷ್ಟು ಆಗ್ಬೋದು ಎಲ್ಲ ಕೂಡ?
ಅದು ಆರ್ಟಿಕಲ್ ಅಸೆಸ್ಮೆಂಟ್ ಆಗಿಲ್ಲ.
Now 2 acres she is willing only to take now, and you are not willing to give them 2 acres. No, they said they want to retain 2 acres, or you want to give 2 acres to them. You must be given the dependent should be given more of them. Are the parties before the court now? Second wife, daughter's son. First wife. Jaikumar is the son. Jaikumari is dependent number 8, second wife. Who is the children? Who is come now before the court? Children of Jaikumari. That is their client. Your client has come. You are Sushila, you are the plaintiff.
Some of the properties, my lord,
Okay, that would be, no, they would not be entitled for that one. Now this the plaintiff is ready to give 2 acres, or you are ready to give? What is the question of you giving? They have to give. Because you are the wife, children of the second wife, and dependent number 1, your father, is not in good terms with you, right?
property, my lord,
Correct.
So all those properties will not taxed.
Now he's claiming as a matter of right. He's claiming as a matter of right. ನನಗೆ ನಾನು ಕೊಡ್ತೀನಿ Two acres, I think he should retain and give others to the plaintiff. If the plaintiff is ready for settlement, then we will refer to mediation. Otherwise, we will not. Is there? No, we will list it in the afternoon. You get instructions, then we will refer it to mediation. Why should we give one more date for this? Make an effort. Let us see. Let us see. Let him make an effort. Otherwise, again, it will be just lying this way. Nothing will happen in this. Fast forward. Mr. Mandana. Awesome. Let's say 13657 is preferred by
Both the by one plaintiff and another one. By Boraya, that is correct. This is number 182 of 2005. Then when I respond, that
see, Malaysia is the plaintiff in invoice number 112 of 2005. So you are the plaintiff, Malaysia.
Boraya. You want to break it with number 182. Therefore, two RS were filed. Therefore, two RS are common between the
Yes.
regular agreement. And in the case of the Borai in Milan, that the father purchased piece of property, that is 4 acres 13 hectares, in 1902, and he continues to be in possession, except that the father had mortgaged 1 acre 19 hectares in favor of Parimal City. So the very similar document is not been taken into consideration. I have produced the document just before the document that I will refer. RS number 1 is taken to the 50. I have produced the
That is pertaining to a different property.
no, then property, both of them are paying the property.
It's different, yes. Different exchange, same property. Yes, yes.
And along with my application, dated everything delivered to 1961. Just to kind of come to page 5, my lad.
Yes.
Would you do the top one? Would you do the hosting? Payapura Gramadali, ಶಿವಬಸಪ್ಪನ ಇರೋದು ಮಕ್ಕಳು ಕಾಳಸಿಕ್ಕಿ ಅವರಿಗೆ ನಿಜ ತಾಲೂಕು ಹೋಬಳಿ ಕಪ್ಪಲಾಪುರ ಗ್ರಾಮದ ಇರುವ ಕೆಂಪಯ್ಯನವರ ಮಗ ಸಿದ್ದಯ್ಯ ಮೇಲೆ ಮಾಡ್ತಾರೆ. This is the market. Kindly come to watermelons, about 6 lines of the water. ಕಪ್ಪಲಾಪುರ ಗ್ರಾಮದಲ್ಲಿ ಆಧಾರ ಮಾಡಿದ್ದೇವೆ. ಓಕೆ ಮಾಡಿದ್ವಿ. ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 45ನೇ ಸರ್ವೆ ನಂಬರ್ 4.5 18 ಗುಂಟೆ ಆಕಾರ 4 ರೂಪಾಯಿಗಳೆಲ್ಲ ಜಮೀನಿನಲ್ಲಿ mortgage deed. Now, Mr. Kindly come to the filings recorded by at page.
Yes.
Page 46.
46.
Page number 40.
Yes.
CW minor cannot be the borrower. In page 12, it's stated as my father mortgage part of the property taxation of 2 acres. It's actually 1 acre 18 meter. By inadvertent, two acres. Document made 1 acre 18 meters was mortgage. This part of evidence is in contradiction to the state government in point number 12. Considering the degree taken by him, point number 112 of the it amounts to
those various treating control. Really true that what with father, what will prevent it? Going number one is very serious. But before that, this is the that at that time was market made by the product and they must reduce by the support of the government. Detail we must got exam one within if it goes to the question of the substantial case is given, then it showing so it is registered mortgage in 1967. This I don't know whether this trial both are this is the document 1961 document. There are two documents for 1967. It has not been mortgaged by the family of the plaintiff. That is the appellate.
There was in the year 1964, this Siddhaya and his sons,
I will go to that aspect.
Bairaya and Javaregowda, they sold this property to the vendor of the plaintiff to Tirumala Shetty.
According to the case of Malaysia, this property on 27 1970 from one Tirumala Shetty.
Correct.
Then Tirumala Shetty should have the title. Tirumala Shetty should have purchased this property from Siddhaya on 26 1964.
Siddhaya is your father.
According to him, this Siddhaya is not, doesn't belong to me at all. It's not. As a matter of fact, was filed by women who was filed by the respondent Malaysia. It says my lord that I am a stranger. Stranger. But later on, madam, he produced some genealogical tree. And so madam, he belongs to my family. But this is
The sale deed executed by this Siddhaya and Bairaya and Javaregowda. Is that
they are not the owners at all. They are according to my it's a concocted document. Must be this entry, this entry are not forthcoming from his encumbrance at all. It's entry. Page 19 of the appellate court judgment have produced the encumbrance. These 1977 deeds or 1964 deeds are not forthcoming in the encumbrance certificate file. Or page 57. This is page 19 of the appellate court judgment. Or has challenged the litigation before the commissioner to the Nara 3 number 482. I will say this district at the rank AC, thereby confirm the litigation entry in the name of Malaysia. By such being the case, we have the court the reason that column number 15 and 16 issued by the commissioner are silent about the digital statement in the name of the Malay. One should not doubt the validity. According to me, these statements are the over. The person who alleged to have told, that is Siddhaya and his children, they do not belong to my family. And they are not related to people, not so crazy. What is the 1964 it could record 1964 madam. ಗ್ರಾಮದಲ್ಲಿ ಕಪ್ಪಲಾಪುರ ಗ್ರಾಮದಲ್ಲಿ ಜವರೇಗೌಡ ಎರಡು ವರ್ಷದ ಜವರೇಗೌಡ ಇವರಿಗೆ ಗಾಡಿಯನ್ನು ಹಾಕಿ ತಂದೆ ನಿಮಗೆ ಭೋಗ್ಯದ ಸಾಲ ತೀರಿಸಬೇಕು ಮತ್ತು ಚಿಲ್ಲರೆ ಸಾಲ ತೀರಿಸುವುದಕ್ಕೂ ಮತ್ತು ಉಳಿಮೆಗೆ ದನಗಳನ್ನು ತೆಗೆದುಕೊಳ್ಳುವುದು. The document produced by me, now I brought it. It has been executed by me, by my father.
Now you say there is a mortgage.
Mortgage. This is the same.
You say there is a mortgage now in favor of the Kada Shetty.
by father of the
Siddhaya.
father of present appellate.
That is Siddhaya.
అయితే ఈ 4 జన వాళ్ళు right comes to conclusion. What case did has executed by Javare on his behalf and on behalf of children, minor children. They did not have right. So therefore, father may not also have the title.
Yes.
So therefore, when the court comes to the conclusion that the right has been proved by them. Judgment 20C in the case of the trainee, he says, "Man, I am a stranger." That page 33 minutes.
Danger andre
ಅಲ್ಲ ಪೇಟೆಂಟ್ ದಾವ ಹಾಕ್ತಾರ ಒಂದೊಂದು ಅಧ್ಯಕ್ಷರು he says, "I am stranger to him."
because he was a minor then. No, he was a minor when he sold. This was a suit property which has been purchased from Tirumala Shetty. Oh, Tirumala Shetty.
ತಿರುಮಲ ಶಿಟ್ಟಿಗೆ ತೆಗೆದಿರಬೇಕು.
Tirumala Shetty Siddhaya has sold by Goraya.
Right has to be because he has come
That
up.
has been failed to be established by you by the before the court's below.
According to me, I am claiming by inheritance. According to him, he is
You were aged about 2 years. According, you were aged about 6 years or 2 years, whatever. At that point of time when the property was sold to Tirumala Shetty.
I am claiming my inheritance.
Yeah, Sanna? As per the sale deed. Yes. Then on page 6. Yes. हाँ Sanna, हाँ. हाँ.
He's not put alert, Sanaya has not published. So his coin has alert the Kapega, Kapega. This property is
Siddhaya, son of Kempegowda. But the Sannaya is also called as Kempegowda.
Whatever the sales, now the market has been executed. Sanaya, son of the Siddhaya, son of Kempegowda. But it is not 1860 of Pellet, 1911.
But instead of in favor of Tirumala Shetty.
Yes, most important. Siddhaya, son of Kempegowda. Once the depositor Siddhaya Kempegowda is the Kempegowda. If the concluded Siddhaya,
No, this Kempegowda's son is Siddhegowda in the genealogy.
In the cross examination, he categorically admitted father murdered Siddhaya. Taking the advantages,
No, see, there is one Kempegowda. His son is Siddhegowda. And Javaregowda and Sannaya are his two sons. And this Siddhaya.
Siddhaya's father also part of the Whatever the market of the attention in the rate 182. Father himself is there. What are taking the advantage of the name of his father. Upon the date of the state in the year 1902, the Sidaya Boda, son of Temple, he is about 35 years. And he is about 35 years. And whatever the document, whatever the years, which is Sidaya, son of Sandaya alias Temple, he died in the year 1984. But the death certificate is produced for the year 2012. By the age melon, he is aged about 27 years.
Certificate number filing a petition
I think the separate day. Schedule is different. Instead is also different. White claim is only as 20 established.
Also record.
Established. Son of Sidaya, son of Kempegoda. Before the trial court as well as the appellate court.
Both the suits are for declaration. Both the suits for. So Malaysia Fire's suit for declaration was decreed. Declared 20. The purchase which he has made from Tirumala Shetty. And Boraya's suit for declaration. Maker 17 juntas, the basis of the inheritance. Inheritance. So,
Total estate interest may not be two.
Once you claim under the safety, he has to prove the title. Here may not, section 26, as the mentioned, point below, section 26 may not give that genealogical tree,
total the document now which is sought to be produced, he says that there was a mortgage in respect of the
1 acre 19.
1 acre 19 guntas in favor of this Kada Shetty. And now, according to them, this Tirumala Shetty had no right because they had already mortgaged the property in favor of Kada Shetty, is the contention of the appellant. Now, according to you, what the property they are seeking to be mortgaged in the year 1961 in favor of Kada Shetty is a different property, different extent, and not the very property. And schedule is totally different from the schedule which has been mentioned in the suit property. Yes. How does kindly come to the claim?
Stand of the painting, so far as the relationship according to no merit, is given merit as a equal step relative. That's what painting is page 33. This is the merit 112.5, which is Malaysia, the respondent here. The social properties are the self-accord properties of the gift. The same was purchased under the Code 1970 for valuable consideration of the so it's allowed to go up by one Tirumala Shetty, not Javara Shetty. The mother of the painting purchased this property by name Nasama on behalf of the minor son, taken as a minor guardian. The mother of the painting is no more. He died in 2003. The vendor of the painting purchased this property and the Shetty began working with the painting from one Sidaya and his son Vailaya and Devaragoda. Not for a Vailaya. If at all, friendship, I belong to the family. Then they would have said, earlier it was mortgaged by our family, and therefore we have purchased. Then, since the date of purchase, the painting has been in possession and enjoyed the use. After and finding pertaining to well, at father came to see 293, petition for the first time, has came to after X55. Came to be changed the name of Malaysia only 92-93 as per Exhibit 35. At the time of purchase of the property, the same was mortgaged to one Kada Shetty of Adil Village for the world. The vendor of the painting received the consideration 1,400 and directed the painting to the mortgage meantime, son, daughter, and wife of parasitic, wife number 114 and the wife of the court against the plaintiff and mother for recorded party memo. The said suit was defeated on point out. The plaintiff realized party memo. The defendant is an utter stranger, utter stranger with social property, where no manner of right, title, or interest, much less possession over the social property. If at all manner, as per the genealogical tree, at page 14, come back to Appellate Court judgment, next page 14. If at all manner, he had come to our family, he would not have said that you are a stranger to me.
That is in the context of this Javregoda's family. He is not belonging to this family. That doesn't mean that he's entirely saying something which is, his suit is based on the magistrate salary.
Our family.
That is only in a suit for declaration. He is not placing his reliance on an inheritance, whereas you are placing reliance on an inheritance. So where is the question of whether he has said it is an utter stranger? It hardly matters. You can't read the other part.
Page 14, that is the genealogical tree, found in
Yes.
the salary of 1964.
Senior counsel, we are in a second appeal. You are aware. You are aware about how much title is with the limited scope of the second appeal before this court.
I understand.
You are well
The
aware.
date is not true. The vendor's title, the vendor did not have state title. Only on that aspect.
That you have failed to establish before the trial court and the first appellate court. You have failed to establish that.
There is an evidence contrary to the material evidence, findings contrary to the material evidence and records. This document has not been taken into consideration. Whether you want to say this, the previous vendor had any right to edit this property.
For the first time, you are taking such a contention before this court. Was that in your written statement? Was that in your plain? Did you take any averment in your plain? All is silent. For the first time, you take up a new contention that there was a mortgage and this Tirumala Shetty. Where is your stand? Where is your stand? And if there is a stand, it has been considered. Where is your stand? Plain pretty adequate.
Page 35 number 6. The facts of plaintiff case number 182. Plaintiff is the other owner in partition of social property. But
Yes.
the social property which is not part of plaintiff is there, and is there, not Kempegoda.
So he Siddegowda, his father is called Siddegowda, Kempegoda, Sannaya. Okay, Kempegoda Sannaya. Okay. He is called many names.
The total extent of land is 745 and the total extent of 4 acres. The father of the plaintiff mortgaged the part of pension property to an extent of 2 acres in favor of one party. By mistake, I 2 acres, but it's not 1 acre.
And mistake anta iradu illa. Your main government system. We can't say we can't. We can't correct this, Alva. Neither you can correct, neither we can correct. It is there on record. You can't improve your case here.
Documents, registered documents, speaks like that.
Whatever. Now this is your government.
The mediation accepted in this Nima number 1 of 7674. As per order of Tasida, data and finding stands in the father of plaintiff. Mortgages, that is mortgages there. The defendant and his alleged vendor have taken undue advantage of the and also have become plaintiff and family member. Stated in 1964 to Dismissal for 1970. The part of the painting purchase the amount is certain number. So, going on, every government, according to that, and which son of Kampala,
There is, there is not even a single government in your written statement. That is the first mortgage. This is another extent. The total extent is 4 acres, 7 guntas. You don't dispute. So 1 acre, 19 guntas. There was a mortgage in favor of this Tirumala Shetty or Kada Shetty by Tirumala Shetty itself. ಆ ಸೂಟು ಆಯ್ತಲ್ಲ ಡಿಗ್ರಿನೂ ಆಯ್ತು. Now you are taking a separate stand. No, I have also given this property to this another person, Kada Shetty, and that property, whereas that property is totally different because it comes, if you measure 1 acre 19 guntas and 1 acre 19 guntas, it will give you figure of 4 acres 7 guntas. So half portion ಮೊದಲು ಮಾಡಿದ್ರ ಇನ್ನೊಂದು half portion ತೋರಿಸ್ಲಿಕ್ಕೆ ಈಗ.
ಅದೆಲ್ಲ it is not forthcoming.
That's all, Mr. Senior Counsel. So many facts will dictate in the afternoon. You can come after that. Yes, we'll dictate in the afternoon. Just look into the facts.
So that
Yes. Yes, Mr. Chandrana. 1 lakh.
Not
paying.
Pay what we have is only 100. Is a vacant site. It is village. 35 into 39 into 45.
Yes. What is the, it is for listed for admission or a final hearing? It is listed for final hearing, right?
Was decreed. Initially, suit was filed for declaration and permanent injunction. Subsequently amended to delete the prayer of permanent injunction and adding mandate injunction. On the mandate injunction, I was required to pay the court. That was not done. It was a lapse on the part of the
But the first appellate court has given you the liberty, you has given you permission to.
Appellate court confirmed the judgment and decree.
But says.
Meeting court, great court saying, cost of this and all that.
There is the provision to lay cost. CPC study? Within 15 days, you had to pass within 15 days of the passing of the decree, within 15 days of the passing of the decree, you had to pay the court fee.
From the order. But there is a judgment which says that even after passing of the decree also 4 years. You are actually very funny. No reasons have been assigned except saying. Therefore, I was of opinion that absolutely I do not find any reasons to integrate the judgment or for the character. However, since the plaintiff has not applied the mandate requirement as per judgment, they will generally dispose as to integrate contract. As the requisite mostly was not tried by plaintiff in time. So in the present case, the decree is not implemented. It is not better. Therefore, the latches on the part of the plaintiff regarding payment of court fee. The learned counsel for the respondents are relied upon, it can rendered by a high court. The Devanta versus Court, ILR 76, Karnataka 1701, very discussed that court fee act does not prohibit courts for collecting court fee even after decree. So, keeping this principle in my mind, and in the interest of justice and equity, the application that is IA number 2 filed at CPC by the respondent is liable to bear out subject to condition that the decree is not implemented. It is the present case, the decree is not implemented. Therefore, I was opinion that absolutely The plaintiff has to pay court fee, first payable to defendant, as the plaintiff has violated terms of the agreement contrary to order 20 of TPC. Since he did not pay court fee, the defendant in the rate of possible.
And cost was imposed on to pay some amount to them. Cost of rupees 1 lakh is imposed.
Sufficient to the lordship fees. So far as court fee is concerned, that is between the
Court and-
plaintiff and the government. But the defendant has nothing to say.
Plaintiff and the court. Plaintiff and the court.
Government is the person who will recover the revenue. So far as the defendant is concerned, he has no say in the matter, he is not concerned with it. And the
Yes, they have not
judgment
charged.
can become final.
Plaintiff is before the court in the second appeal, assailing the plaintiff, right? Legal heir of the plaintiff. Jayamma is the plaintiff.
Jayamma is the defendant. Venkat Narayan Murthy is the plaintiff. Appellate's plaintiff second appeal.
Plaintiff. Who is she? Huh? Yaru?
Respondent.
Respondent. ನಿಮ್ ಲಾಯರ್ ಇದಾರಲ್ವಾ?
State appeal.
We have rejected the
Removal file. Not in the best of the wants to retire.
ನಿಮ್ಮ ವಕೀಲರು tell her that memo for retirement was filed and that has been rejected. ಅವ್ರಿಗೆ ಕರೆಸಿ. Let him come. ಕರೆಸಿ ಅವ್ರನ್ನ. Let him come. Your party is not willing to pay any amount to him.
They have practiced on the property for the last 32 years. He has no tax. He has been harassing me. That is what he is complaining.
ಎಷ್ಟು ವರ್ಷದಿಂದ ಅಲ್ಲಿ ಇದ್ದೀರಾ? ಮತ್ತೆ ಅಲ್ಲಿ ಇದ್ದೀರಲ್ಲ 40 ವರ್ಷ, ಅವ್ರ ಜಮೀನ್ ಕೊಡ್ಬೇಕಲ್ವಾ ಅವ್ರಿಗೆ ವಾಪಸ್ಸು? ಆಗ ಆಯ್ತು, ನಿಮ್ ವಕೀಲ್ನು ಕರ್ಸಿ ಇಲ್ಲಿ. ಮತ್ತೇನ್ ಮಾಡ್ಬೇಕು ನಾವು? ಅವತ್ತೇ ಹೇಳಿದ್ದೀವಿ ಏನ್ ಮಾಡ್ಬೇಕು ಅಂತ ಅವ್ರಿಗೆ. No, we have rejected the retirement memo has been rejected.
The husband outside. He is fighting on the property.
Against the decretal of your suit, they have not prepared any appeal. No appeal is.
RA was filed
Advocate
because
and
this case.
Let him come. Pass over, pass over. ಅವ್ರಿಗೆ ಹೇಳಿ ಕೊಡಿ. Yes, next one.
Yes, Ramaswamy.
Why all passovers? When will you argue the matters? Civil court nalli na. Civil court matter is important or high court matter? We will dismiss the appeal for non-prosecution if you make such submissions. You want to, your senior wants to go to civil court, but he will not attend the court at the high court. Is it so? No appearance on behalf of an appellant. The passover is not on the ground that his senior is held up in civil court. Such type of submission is not acceptable to this court. Appeal is dismissed for non-prosecution. Dismissed for non-prosecution. Mr. Sharad Gowda. For the plaintiff, defendant. What happened before the trial court? Court was dismissed on what ground? Prior partition.
This may not be, this may not the wife may also. Yet shouted order is five children. But Maya, yes, Pegoda, Shankar, Ananda, Krishna, and Rama. There was a plaintiff hearing is the wife of Maya, yes, Pegoda. And my lord, the children are the. There was a contention was taken by the.
You are the wife of Timme Gowda. Timme Kempe.
Maya, yes, Pegoda.
So you are the wife of. How do you establish your relationship between this Timmaiya Kempe Gowda? What is the documents produced by you? PA. What is exhibit? Is marriage invitation or Lagna Patrike between the Kempe Gowda. Exhibit P8. And exhibit P9? Marriage invitation card. Why was this document not disbelieved, or rather, why was it disbelieved by the trial court? When did Kempe Gowda die? And the marriage date is? '82. What is the reason indicated by the first appellate court to say that you are not entitled for share?
Has not produced any document.
What is the reasoning of the first appellate court? She is anyway arguing, let she argue. Yes. Miss, you are ready, right, in the matter? Right? If you read exhibit, para number 20.
What's appellate court below?
You are exhibit P8 and P9. P8 is the number. But it's small. Small assumption. But P9 is for a recent law.
What is P9? P9 is the marriage invitation. Marriage invitation card is dated. And how does the first appellate court assume? Texture. And that was not disputed by the.
When some stranger comes to find the suit, saying that he is my husband, I go on with mother and invaded for his property. What will be the reaction of the all of them will not be convicted. They will not be only D3 and D6 persons with that statement.
What D3 and D6 the other brothers?
D6 is the sister of the husband of the baby.
What is the content of the written?
Their only condition is that
they don't even say that she is married to somebody else or.
it's not the way, that is what if I take the logic. That is grounds on which vision of law is documented. Second vision of law.
Yes.
Is that why all the defendants are not
No, what they said is that the brother, that Tammaya, has died unmarried. And that is all what they say.
There is 1986. Marriage is 1986.
So according to them, it is very unlikely that they get married at the. What was his age at the died at the date of?
They were actually suffering from kind of ailment. Therefore, this plaintiff was there at their own sex. Even the plaintiff's brother was there at their own manale. ಆಯಾ ಕಾಲದಲ್ಲಿ ನೋಡ್ಕೊಳಕ್ಕಾಗತ್ತೆ ಅಂತ ಇವ್ರು ಮದುವೆ ಮಾಡಿದ್ರು 4 ವರ್ಷದಲ್ಲಿ ಆಗಕ್ಕೆ ಕೊಡು ಫಸ್ಟ್ ಅಪ್ಲೈಟ್ ಕೋರ್ಟ್ ಸ್ಟ್ರೇನ್ಸಿ ಸೇಸ್ the election voter list prior to 1982 after 1988 has not reflecting their names ಒಂದು 5 ವರ್ಷಕ್ಕೆ ಒಂದು ಸತಿ ಆಗುತ್ತೆ one time ಅಲ್ಲಿ exhibit P12 and P11 gave for voter list my name is there the first applied court finds fault ಅದು ಅದಕ್ಕಿಂತ ಹಿಂದಿನ ಜನ ಹೋಗ್ತಾ ಇಲ್ಲ ಇಲ್ಲಿ
Copies for the other side. Some HP Chandrasekhar.
And P1 to P6, P4 is the son of the priest who performed the marriage.
So he gives an evidence.
That marriage was performed. P2 are all villagers who are present at that point of time. They said that this marriage.
So the evidence
comes into my head.
The evidence of PW2 to PW5, huh?
Yes,
6. And corroborated with the evidence of with the
9, 10. I also produced the list of gifts which I received in the marriage. That is P11. What more words I explain? Most important thing is when some stranger woman comes, everyone will not be convinced. Why will other defendants remain quiet? And none of them dispute these documents. They do not say this Latla Patrika is created, this voter list is created. They do not examine the returning officer who prepares the voter station, calls him to the box and says this is a created document. In the absence of rebuttal notes,
heard the learned counsel for the appellant in part. Heard the learned counsel for the appellant. There is no representation on behalf of the respondent. This is the matter tomorrow for further hearing.
all
Your colleague was there. Eighty. Mhm. Is Mr. Patil Karegowda? Also. Srinivas. Ah. Against the decretal of your suit in part, you have not preferred any appeal. So you are happy with the decreeing of your suit in part. The defendant is aggrieved by the order of granting you the some decree in favor of some properties. Relationship not in dispute.
Maybe not relying upon the appeal.
No, bill is not proved. But
See, it is true. We have actually challenged that. We have to seeking partition upon the sound part. Only 8
so bill property has been held in their favor. Other properties has been granted. I mean, allotted, share has been allotted. Srinivas got the report. You changed the password. Mr. Mahesha. This divergent. Huh? What is the suit for? Ah. Declaration based on the lead. Permanent lease. Permanent lease. Huh? Time frame was there for that mortgage and so now you are the plaintiff, right? You are the plaintiff. Your suit is for declaration and injunction based on the registered sale deed which your father purchased in the year 1960. And then, according to you, the plaintiffs, according to you itself, they have leased this property to the dependents through mortgage or registered sale deed and it's a mortgage. What is false? The mortgage is false. There is no mortgage, they say. Then what is the right they are claiming under? Why did the trial court dismiss your suit? Who said it is leased? Allah, did the plaintiff or the defendant make an averment that there was a lease? No. Nobody has raised such an complaint. And what is the substantive question of law claimed by this court? Frame ಮಾಡಲಿಲ್ಲ ಅಡ್ಮಿಟ್ ಆಗಿದೆ ತಾನೆ It's been framed, whether the first appellate court was justified in reversing the finding of the issue number 1 and 2, holding that the plaintiffs have proved that they are in lawful possession as on the date of the suit, and the defendant tried to interpret. They are allowing the appeal of the plaintiffs in settlements. Mahesh comes before the court. Pass over. We'll take up your matters at 4 o'clock. We have got parted matters at 2:30. 2:30, right? Pass over there, right? This is the default number. Yes, Mr. Afternoon will be taken. We are going to dismiss your petition. Yes, yes. You come. Yes, yes. I. Yes, Mr. Manjunath or yes, we'll take up in the afternoon. We'll take up it after 4 o'clock. We have got some parted matters. 4.
Court officer Saibra. Court officer Saibra.
List number 3 da.
List number 3 ಯಾವಾಗ ಕರೀತೀರಾ ಸರ್?
231 ಮ್ಯಾಟ್ರಿ ಇಲ್ವಾ? ಟ್ಯಾಕ್ಸ್ ಆಮೇಲೆ ಸರ್ವಿಸ್ ಕ್ಯಾಸ್ಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ಏನಾಯ್ತು ಈಗ ಜಸ್ಟ್ ಒಂದು ಇನ್ ಕೇಳಿದ್ರು ಅದನ್ನೇ ಲೇಬರ್ ಮ್ಯಾಟರ್ ಟ್ಯಾಕ್ಸ್ ಗೊತ್ತಿದೆ ಅಂತ ಇಟ್ಕೊಂಡಿದ್ದು ಬೆಳಿಗ್ಗೆ ಈಗ ಇನ್ನೊಂದಿದೆ ಅದೇನೋ ಬೇಕಾದ ಕೇಳ್ಕೊಡಿ RS ಎಲ್ಲ ಲೇಬರ್ ಮ್ಯಾಟರ್ ಓಕೆ ಮಾಡ್ತೀನಿ ಅದು ಇನ್ನೊಂದು ಫ್ಯಾಕ್ಸ್ ಮಧ್ಯಾಹ್ನ ಡಿಸ್ಕಷನ್ ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು ಅದು ಏನಾದ್ರು ಬೇಕಂದ್ರೆ ಕೇಳಿ ಡೈಲಿ ಇಟ್ಟಿರ್ತೀನಿ ಇಲ್ಲಿ ಅಲ್ಲೆಲ್ಲ ಇಟ್ಬಿಡಿ ಸರ್ ಅಲ್ಲಿ ಮೂಲೆಯಲ್ಲಿ ಇಟ್ಬಿಡಿ ಕೆಳಗೆ ಅಲ್ಲಿ ಇಟ್ಬಿಡಿ ನಾನು ಬೇಕು ಅಂದ್ರೆ ನಾನೇ ಬಂದು ತಗೊಂಡು ಹೋಗ್ತೀನಿ